Here's another key piece of information when it comes to risk management. A lot of the forms, whatever form system you're using, have large blank sections. The addendum and amendment are key ones. Most of the page is a blank space for the agent to write whatever they want to write. A couple key points here. First of all, a lot of times there is a form already written that addresses the situation that you're dealing with here, right? One thing that we will sometimes see, someone will use an addendum or an amendment or the other terms section on the purchase agreement to write things like, this offer is contingent on the buyer selling their other home. Say something like that. Sounds simple enough. However, there is of course a full form for this called the COP, or contingency for sale of the other property. And so you want to use the form that's already pre-built for that. Your one sentence write-in sounds simple enough. Everyone's kind of comfortable with it. But the reason there's a whole form for it is there's a lot of common problems that come up because people don't typically think about them. And none of those things are addressed on that one-liner, but they are addressed on the form that's dedicated to handle that situation. Other things like a seller staying after the close of escrow for a few days or a few weeks, or potentially a few months. There's 2 different forms for that. And there's any other number of things, like if your scenario is handled by a form, use the form. Don't freehand it. Here's the other way that this can really ramp up as a problem for an agent. That's why it's under the risk management category, is if you write something and there was a form that was an option, could be accused of essentially practicing law, because you have these forms that are vetted by attorneys. They're actually backed by the California Association of Realtors and their attorneys, and you chose not to use them. You just freehanded something. So why did you choose to act as the attorney? So if that language in the contract that you drafted, sure, your client signed it, but you drafted it. If that language doesn't hold up for them, or they cancel and lose their deposit, or some other problematic thing happens, and someone else says, why did your agent write this? There's a whole form built for this. Why did they do that like this for you? What are they doing? That's a risky spot for you to be in, and you can imagine some fingers pointing at you for not doing this right. An experienced attorney first told me, long addendum is nightmarish for an agent if that goes to court, because if that long addendum wasn't vetted by an attorney, there's any number of problems with that. A whole other category where I've seen very seasoned agents write things like, so-and-so releases liability if they do this action. There's very specific requirements to writing liability releases and trying to change some of these things in the contract. It's very potentially a legal disaster that you're creating for yourself and your client if you overreach with these blank spaces that are there, and it's tempting to just write it, but you want to watch out for that. The other thing I will say, this is more a newer thing that's come up, is you've seen things about some of the AI tools now that are supposedly like passing the bar. And so we've actually seen some contracts and some addenda that we will look at it and what's going on here? How did this come about? This doesn't really make sense. It sounds good, but it doesn't really address the situation, and it's really long and it sounds attorney-like, but wrong. And come to find out, the agent, after a conversation with the client, had the AI write this clause that they put into the other terms section of a contract, and can potentially, as you can imagine, cause all kinds of problems. You just don't want to do that, and of course it would look like that agent had drafted that, then therefore be potentially responsible for it. So long story short, avoid long freehand written text in your contracts and addenda. And then the last thing I would say is just make sure you know the contract. There's a lot of times people will write something, but there's actually a checkbox in the contract that handles that whole situation. So if you had just checked the box, you wouldn't have needed to freehand this information that is now problematic. There's a properly written, kind of legally vetted option already in there. Things like the appraisal gap. A lot of people writing their own appraisal gap language, but there's an appraisal gap section in the contract. Same with like closing cost credits. You don't see a lot of disputes about that, but there's a section pre-written into the contract for that. But we'll see a lot of times people free writing that kind of thing. Contract has built-in language that it's an as-is transaction, and we'll sometimes see people writing, this is an as-is transaction and so waives their rights, blah, blah, blah. You don't want to do that. You already have as-is language in the contract. Again, just knowing the contract will help you avoid either duplicating or muddying the waters with whatever extra language you might write. Hopefully that helped. You are going to have to communicate some things in these contracts. You just don't want to overdo it. Make sure you have the good foundation of knowing what's already in the contract, what the other forms are available to you, what clauses has your company pre-written. When needed, check with a mentor or manager to have these things looked over if you're newer and uncomfortable. With that, hopefully that helps. Watch out for these long free-handed clauses. Thanks for watching. I hope this was helpful. If you learned something or if this helped you solve a problem, follow me for more.